Good evening, attorney. Good evening, classmates. For today's video, we will discuss about the remedies for the breach of contract, and under it is the remedies of a seller and a buyer. And also, we will discuss about the extinguishment of a sale, causes in its general. As we move on to the discussion, we will first discuss about the remedies in cases of immovable or real property, the remedies of a seller. First rule that we need to know is the doctrine of anticipatory breach. Under Article 1591 of the Civil Code, if the seller has reasonable grounds to fear the loss of the immovable property sold in its price, he may immediately sue for the rescission of the sale. Again, if there's a reasonable grounds in those cases, we apply the 1591. But if there's no reasonable grounds, then we just apply the Article 1191 of the Civil Code on the rescission of the obligation. So, the next we need to know is 1592. As a general rule, 1191 in case of a breach of a non-payment of the buyer, then the seller is entitled to the rescind or ask the rescission of the contract of sale. However, the right to rescind is subject, of course, to the special rules provided in Article 1592. On the second scenario is a failure of a buyer to pay the price. A rescission under Article 1592. Under Article 1592 of the Civil Code, in the sale of immovable property, even though it may have been stipulated that upon failure to pay the price at the time agreed upon the rescission of the contract shall at the right take place, the buyer may pay even after the expiration of the period, as long as demand for the rescission of the contract has been made upon him judicially or by a notarial act. It is important to take note that this rule, this 1592, will only apply to absolute sale. In other words, 1592 does not apply first to the sale on a real property on installment because the governing law here is 6652 or the Maceda law. We can discuss it thoroughly while moving on to the discussion. The rule also does not apply to the contract to sell or conditional sales because the sale does not exist as of yet. Also, we must take note that this because if we are presenting with a problem, we have to determine first what is the nature of sale, whether it's absolute or conditional, or if it's a contract to sell, and or the sale is covered by the Maceda law because they are installment basis. So those are the rules in the immovables or the real property. So after we discuss the immovable property, let's move on to the remedies of the seller in case of a movable or personal property. First, we will take up the Article 1593 of the Civil Code. The ordinary remedies of a seller. In the sale of immovables, in the case of a buyer, upon the expiration of the period fixed of the delivery of the thing, should not have appeared to receive it, or having appeared, he should not have tendered the price at the same time, unless a longer period has been stipulated for its payment. The seller maintain an action to rescind the sale. Now, when it comes to the sale of goods, the seller may bring an action to the specific performance or an action for the price under Article 1593, and these are the three cases which an action of the price is available. Second is the sale of goods. Non-payment of a price by buyer. There are three instances or there are three scenarios that we can discuss in this topic. First is the ownership transfer to the buyer. Second is to transfer the ownership to the buyer. And third, when the price is payable on a certain day. So let's discuss the first situation, the ownership transfer to the buyer. Where the ownership of the goods has passed to the buyer who wrongfully neglects or refuses to pay according to the terms of the contract, the seller may maintain an action against him for the price of the goods, an action for a specific performance. Second is no transfer of the ownership to the buyer. When the ownership of the goods has not passed, if they cannot readily be resold for a reasonable price, the seller may offer to deliver the goods to the buyer, and if the buyer refuses to receive them, may notify the buyer that the goods are thereafter held by the seller of a bailee of the buyer. Thereafter, the seller may treat the goods as the buyer and may maintain an action for the price. Lastly, when the price payable on a certain day. When the price is payable on a certain day, irrespective of the delivery of the title, and the buyer wrongfully neglects or refuses to pay such price. And the seller may maintain an action for the price although the ownership in the good has not passed. However, it shall be a defense to such action that the seller, at any time before the judgment, in such action has manifested an inability to perform the sale on his part and intention not to perform it. So let's move on to the when the buyer wrongfully neglects or refuses to accept the goods. In accordance with the following rules, first is damages shall cover the estimated loss directly and naturally resulting in the ordinary courses of events from the buyer's breach of contract. Second, when there is an available market for good in question, in the absence of a special circumstances showing proximate damage of a different amount. The measure of damages is different between the contract price and market on the current price at the time or times when the goods ought to have been accepted. Second, if the buyer repudiates the contract or notifies the seller to proceed no further, buyer shall be liable for labor performed or expenses of material amount is necessary on the part of the seller to enable him to fulfill his obligation under the sale made before receiving notice of the buyer repudiation or countermand. And lastly, the profit of the seller would have made if the contract of the sale had been fully performed and shall be considered in awarding the damages. After we discuss the wrongfully or refuse to accept the goods, we will discuss about the special remedies of unpaid seller of goods. So under Article 1525 of the Civil Code, the sale of goods is deemed to have or to be an unpaid seller either if when the whole price of when the whole of the price has not been paid or tendered, or second, when the bill of exchange or other negotiable instrument has been received as conditional payment and the condition on which it was received has been broke by reason of the dishonor of the instrument, the insolvency of the buyer, or otherwise. The term unpaid seller it includes an agent of the seller to whom the bill of lading has been endorsed, or consigned, or agent who has himself paid or directly responsible for the price, or any other person who is in the possession of the seller. So, when a seller is unpaid seller, as defined by law, whether or not ownership over the goods has been transferred to the buyer, the unpaid seller is entitled to the following rights or remedies. So, the following rights or remedies of an unpaid seller are possessory lien, stoppage in transitu, special right of a sale, and special right to rescind. So, we will discuss each. So those four remedies of an unpaid seller that I've mentioned above have a hierarchical application, as in fact the special right to sell and to rescind can be availed of by the unpaid seller only when either of the two or prior rights of a possessory lien or stoppage in transitu have been exercised by the unpaid seller. So let's discuss the possessory lien. The general rule is that when it comes to movables, the seller is not bound to deliver the thing sold. If the buyer has not paid him the price, or if no period for the payment has been fixed in the contract, however, in the absence of stipulation to the contrary, delivery of the goods to the buyers transfers ownership to the latter, and the non-payment on the price does not prevent such transfer of ownership as a result or tradition to take effect. If the seller is an unpaid seller, as defined by law, notwithstanding that the ownership in the goods may have passed to the buyer, the unpaid seller still has a lien on the goods, right, to retain them for the price while he is in possession of them. Where the ownership in the goods has not passed to the buyer, the unpaid seller has, in addition to his other remedies, a right withholding the delivery similar to and coextensive with his right of lien. So there are only instances when when the possessory lien of the unpaid seller is exercisable. The following are: first, where the goods have been sold without any stipulation as to credit. Second, where the goods have been sold on credit but the term of credit has expired. And lastly, where the buyer becomes insolvent. Those are the three cases when the possessory lien of the unpaid seller is exercisable. When the part the delivery affected, where an unpaid seller has made part delivery of goods, he may exercise his right of lien on the remainder unless such delivery has been made under such circumstances as to show an intent to waive the lien or the right of intention. How about when the possessory lien is lost? The unpaid seller of goods loses his lien on the goods whenever these are the instances. Uh, First, the seller delivers the good to the carrier or to the bailee for the purpose of transmission to to the buyer without reserving the ownership in the goods or the rights to the possession thereof. Second, the buyer or his agent lawfully obtains possession of the goods. And third is by waiver thereof. It may be expressed or may be implied. However, the unpaid sale of goods, the unpaid seller of goods having a lien thereon does not lose his lien by the reason only that he has obtained judgment or decree for the price of goods. As will be noted, the unpaid seller loses his possessory lien when he parts with physical possession of the goods, as when he delivers goods to the carrier. In that cases, he still has the remedy of stoppage in transitu, but only if the bearer has in the meantime become insolvent. So after we discuss the possessory lien, we will move on to the stoppage in transitu, the second remedy. Notwithstanding that the ownership in the goods may have passed to the buyer, the unpaid seller of goods has, in case the insolvency of the buyer, a right of stopping the goods in transitu after he has parted with possession of them. Under Article 1530 of the Civil Code, when the buyer of goods is or become insolvent, the unpaid seller who has parted with the possession of the goods has the right of stopping them in transitu. That is to say, he may resume possession of the goods at any time while they are in transit, and he will then become entitled to the same rights in regards to the goods as he would have had if he had never parted in the possession. In order the right of stoppage in transitu to apply, there are requisites. First, the seller, of course, must be unpaid. Second, the goods must actually in transit. Third, the buyers may be insolvent. And fourth, the seller must actually take possession, or he must give notice to the claim or to the carrier or other bailey. Please take note that the unpaid seller right of stoppage in transitu is not affected by any sale or any other disposition in the goods which the buyer may may have made, unless the seller assented thereto. As you will notice, we are mentioning insolvent for stoppage in transitu. Under the law on sales, a buyer is deemed insolvent who either has ceased to pay his debt in the ordinary course or business, or cannot pay his debts as they become due, whether insolvency proceedings have been commenced or not. Now, you will notice that I mentioned that the goods must be in transit. How will we know that it is in transit? So, when goods are deemed in transit, there are two scenarios where the goods are deemed transit. First, from the time that they are delivered to a carrier by land water, air, or other bailee for the purpose of transmission to the buyer until the buyer or his agent in that behalf